Right, please let me get what I want. You see what I did there? A few things you should know about this. First of all, you all know this is one of the greatest songs ever. You may not, however, know the Johnny Marr version is infinitely better than the Smiths.
Good times for a change. See the life I have had can make a good living turn around. So please, let me get what I want.
Well, if that hasn't pulled your heart out, you're clearly not human. I'd love just to sit here and listen to this, but two things would happen. First of all, I'd be a bucket of tears, and secondly, we wouldn't get through this presentation. So look it up. It's just a song you need to know. Anyway, so please let me get what I want. Rights are all about the relationship between the governors and the governed, and we know all about those. Now, when it comes to rights, you can't really move in the rights, in the Constitution for Rights. And of course, we all know about the Bill of Rights. That's the first 10 amendments. That's those out there. And the other ones you need to know, amongst others, things like the 13th, the 14th, the 15th, and the 19th. All of these are very, very important rights. And these are our enumerated rights. They're written in the Constitution. They are there. They're written down clear as day. But you will remember that the 9th of those Bills of Rights says rights not enumerated here do not necessarily not exist, and you'll have to forgive all of those double negatives or the pile of negatives that's stacking up. But what that means is that if it's not written down, if a right is not written down, that doesn't mean that it doesn't exist. And that essentially gave license to these other rights and the various others to be added to it. So the Bill of Rights are largely rights 1 to 10, but we can extend that to look at certain amendments, 13th, 14th, 15th, and particularly the 19th. So those would be our enumerated rights. But again, the 9th Amendment says just because it ain't written down doesn't mean it doesn't exist. And we also have inferred rights. Now, this is getting a little bit more complicated. These are rights that are not written in the Constitution as such, but they are somewhat understood. And they can be understood in two particular ways. The first of those, and perhaps the most important, and the ones really that I'm going to talk about today, are rights not written in the Constitution, but deeply rooted in the nation's history and tradition, or implicit in the concept of ordered liberty. So these are rights that we can think the Founding Fathers would probably agree with. They'd look at it and say, yeah, that's kind of what we meant. We were rushed, we were hungover, we didn't have time to write them all down. But we broadly agree with those. So those are rights not actually explicitly stated in the Constitution, but perhaps you can infer them based upon other rights, based upon the nation's history and tradition. Things like a right to privacy. There's no explicit right to privacy, but the Supreme Court in Griswold versus Connecticut in 1967, I think it was, said, well, if you take these rights and if you add these rights, then you can perhaps infer from that a general right to privacy. And so the state has no right to intrude upon what married couples get up to in the privacy of their own bedroom. Nothing written about that in the Constitution, but by the same token, you might infer it from the general thrust and drive of the Constitution. This is the concept of originalism or original intent. In other words, this is what the Founding Fathers would have wanted if they'd had all the time and all the ability to write these things into the Constitution. So originalism or original intent or textualism, all of these things are different ways of identifying inferred rights, or what the Founding Fathers would have wanted. The next set of rights are extended rights. Now, these are not necessarily rights that the Founding Fathers would themselves have accepted, but perhaps rights that are evident in evolving standards of decency and substantive due process. Now, substantive due process relates back to the 14th Amendment. We're going to talk about that in a minute. But what we're talking about here are things that perhaps were not acceptable in the days of the Founding Fathers, but are acceptable now. The obvious example being homosexuality or homosexual rights or abortion or things along those lines. What we're saying is perhaps the Founding Fathers would have been a bit cagey about it. But hey, that was 1789. It's now, well, time of going to press, it's 2017. So we have to say different times. Once upon a time, we could do that. Once upon a time, we could execute minors. Once upon a time, we could execute people who are who don't understand the magnitude of their crimes. Once upon a time, we could put gay people in jail for being gay. Once upon a time, we could put women in jail for having an abortion. That's what it was. But different times, we've moved on. Now, it should be immediately obvious with these that we're moving further and further away from the original text of the Constitution. And this is what we call judicial loose construction. It's a much more flexible approach to the Constitution. We're looking at the Constitution as a living and an original document. And the further you get away from the Constitution, the more those judges move into the political thicket, because they're moving away from the original text and starting to impose their own values and their own judgments on the text. Here they claim that they are representing the original founding fathers' intent. Had they but whirled enough in time, they would have written all of this stuff. And when we move into judicial loose construction, the argument is different times. That's how it was, but this is how it is. The Constitution has to move with the times or it has to collapse. To which the argument, the flip side of the argument is, well, hang on a second, we've got a process for amending the Constitution. If you've got a problem with the Constitution, don't stretch it to fit, amend the Constitution. But the riposte to that is you can't amend the Constitution. That, again, was written for 1789, and a handful of states you can't do with 50 states. But I'm really now going way, way, way further down the line and into the weeds in this than I really intended. This is supposed to just be an overview, but I love this subject so much that I can't help myself sometimes. I am just going to put these ones up and you can look at them. I presume you can read. The ones you need to know about, really, this is your standard freedoms. This is the one about arming bears. This one is quite funny, and there's a video we can look at later that brings reference to this. This one is not one that's talked about, really, an awful lot. Maybe it should be. It should be talked about a lot more. Because, if they're going through your phone records and your emails, then maybe that's an unreasonable search and seizure. Question that wasn't asked at the time of the passing of the Patriot Act. This is the one we all know about because it's the Fifth Amendment. It's the right to avoid self-incrimination, but it's not really one that comes up an awful lot, although it was fundamental in the process of establishing Miranda rights, which is your right to an attorney, right to the ones they read out at the start of every arrest in a procedural cop drama. Those are your Miranda rights. That's after Miranda versus Arizona in 1965, but that's another story. Moving on to the next set of rights, number 6, we'll virtually never touch on, although obviously it's important. Number 7 is also important, but again, it's not one we come up to. 8 is a humdinger, cruel and unusual. What is cruel and unusual? Is the death penalty cruel and unusual? Is the death penalty for minors cruel and unusual? Is it cruel and unusual to lock somebody up for a crime when they're 13 and never let them out? Is it cruel and unusual to lock somebody up for a crime when they're 13 and only let them out when they're 60? These things are all questions, and it should be evident right here and right now that this is not by any way, shape, or means, or even squint as hard as you like, this is not objective. And so any judgment on cruel and unusual is going to be the imposition of a personal opinion. It's not a matter of law. But again, I'm getting dragged into the weeds. And again, if you are familiar with the difference between normative statements and positive statements, that's one that's going to help you there tremendously. We'll come back to that in class. Ninth Amendment, this is the one rights not enumerated in the Constitution. Just because it's not written down doesn't mean that it doesn't exist, and I hope I've got my negatives sorted out there. And this is the one that says, that whereof the Constitution is silent, the states may speak. If it's not in the Constitution, then it's the state's job to sort it out, and the federal government has absolutely no business going in and passing laws about things that are not mentioned in the Constitution. Where the Constitution does not explicitly give the government the right to go in, and the federal government, the right to go in and make laws, then that necessarily is the jurisdiction of state government. Becomes very, very important with marriage, with voting, and other such substances. Drugs, for one, speaking of substances. Other really, really important rights. The 13th abolishes slavery, very, very important. 14th is this due process, the substantive due process clause. That is what we would consider to be the rule of law. All laws apply to all people at all times and all in the same way. But we can go further than that and say that's due process. Substantive due process means that it must not be, we must not observe the rule of law, but we must be seen to be observing the rule of law. So we go that bit further when we're making sure that everyone has the same protection of the laws. The 15th Amendment is about abolition of the abolition or the extension, of the franchise to include race, and the 19th Amendment, which you'll notice is 4 years after. So 4 years after black men. Sorry, not 4 amendments. Excuse me, not 4 years. 4 amendments. It was an awful lot longer. The 15th Amendment was about in 1865. If I remember correctly, top of my head, the 19th Amendment was in the early 1920s. That's when women got the vote. Yeah, black men very, very happy with the 15th Amendment. It was not until the 19th Amendment that black women got the vote. Now, in terms of rights not easily identifiable in the Constitution, these are the sort of things we're going to be looking at. We're going to be looking at the right to privacy. That was Griswold versus Connecticut in 67. Better check that, 67. We've got abortion. That was Roe v. Wade in 1973. And we've got the fine-tuning of execution protocols in things like Roper versus Simmons and Stanford versus Kentucky and Glossop versus Gross. All of those sorts of things are all very, very important Supreme Court cases. Now, that's an introduction to rights. These are rights that establish clear limits to what the state can do. And if the state, by which I mean both the federal government or the state government, passes an action, be it a legislation or an executive action, that violates one of those rights, then the citizen has the right to challenge that in the court. And so everything shifts towards the Supreme Court, just as everything always does. So if a law is held to violate a right, that will wind up in the Supreme Court. And if an executive action is held to violate a right, like Trump's travel ban, then that too will wind up in the Supreme Court. The Supreme Court will look at that particular action. They will decide whether or not it is consistent with the Constitution. And if it is not consistent with the Constitution, then it's game over and that law is gone. Except it's never really quite that simple. Oh, gosh, right. I was hoping to get onto democracy in the same slide, but obviously that's not going to happen. So instead, let's go back to Johnny Marr. See you for democracy in a few minutes.
So for once in my life, get what I want. Lord knows it will be the first time. Lord knows it will be the first time.
What, that noise? No, I'm not crying. I'm not. I've just got something in my eye. How very dare you? I'm not crying. I'm not, really.